Can anyone grant consent to a search, and what are the limits of their authority? It turns out that the person conducting the search doesn't always have to be a law enforcement officer, and the person giving consent doesn't have to be the one suspected of a crime. In fact, courts have ruled that evidence found in searches based on consent obtained by undercover officers or informers is admissible. In some cases, someone other than the defendant can grant consent, but only if they have actual authority over the premises or effects being searched. For example, a co-occupant of a house can give consent to search the entire house, as ruled by the Supreme Court in United States v. Matlock, 1974. However, if two co-occupants are present and one consents to a search while the other objects, the police cannot validly search the premises. But what if the objecting party is lawfully arrested and removed from the premises? In Fernandez v. California, 2014, the Supreme Court ruled that the police can search the premises with the consent of the remaining co-occupant. And what about revoking consent? Usually, consent can be revoked at any time during a search, and the officers must stop immediately. However, there are two exceptions: airport passenger screening and prison visitation, where the right to revoke consent is not recognized. The rules of consent searches can be complex and surprising, but understanding them is crucial for upholding individual rights and protecting against unlawful searches.